नमस्कार फ्रेंड, आप सभी का एक बार फिर से स्वागत। फ्रेंड्स, सुप्रीम कोर्ट ने एक अहम डिसीजन दिया जो बैंकर्स के हित में है। Borrowers cannot claim extension of time under OTS as matter of right. Supreme Court. The Supreme Court has said a borrower cannot claim further extension of time as a matter of right for making payment under the one-time settlement scheme. The apex court said the borrower has to establish any right in its favor to claim the extension as a matter of right. A bench of Justice M.R. Shah and Krishna Murari quashed the Punjab and Haryana High Court judgment delivered in March, which had granted further 6 weeks to a borrower, a company, to make the payment of balance amount with interest to the State Bank of India according to the sanction letter of OTS. The top court observed that the rescheduling the payment under the OTS scheme and the granting extension of time would tantamount to rewriting the contract, which is not permissible while exercising the power under Article 226 of the Constitution. The modification of the contract can be done only by mutual consent under Section 62 of the Indian Contract Act. Article 226 of the Constitution deals with the power of high courts to issue certain writs. The borrower, as a matter of right, cannot claim that though it has not made the payment as per the sanctioned OTS scheme, still it be granted further extension as a matter of right. There cannot be any negative discrimination claimed. The top court delivered its verdict on an appeal filed by the SBI against the High Court judgment. It noted that the bank had sanctioned a cash credit in favor of the borrower. Later, the bank came out with the OTS scheme in September 2017, which specifically provided for making payment as settled under the scheme within 6 months from the date of sanction, else infructuous. The apex court noted that the bank sent OTS offer to the borrower who accepted it. It said under the sanction OTS, the borrower was required to deposit 25% of the amount by December 21, 2017, and balance amount with interest was to be deposited within 6 months from the date of the letter. The borrower requested extension of 8 to 9 months for repayment of balance amount of rupees 2.52 crores, which the bank declined and directed it to make the payment by May 21, 2018. The borrower then approached the High Court seeking 8 to 9 months to pay the outstanding amount beyond May 21, 2018. In its verdict, the apex court noted that the bank had floated other OTS scheme and offered to the borrower to settle the account, but the company did not opt for them. It said the question which arises for consideration of the top court is whether, in the facts and circumstances of the case, the High Court was justified in extending the period to make the payment of balance amount under the sanctioned OTS scheme while exercising powers under Article 226. The bench said in the sanction letter dated November 21, 2017, it was specifically provided that the entire payment was to be made by May 21, 2018. It is an admitted position that the borrower did not make the payment due to and payable under the sanctioned OTS scheme on or before the date mentioned in the sanction letter. While allowing the appeal, the bench said the judgment passed by High Court granting further time to the borrower to make balance payment under OTS scheme is exercise of power under Article 226 was unsustainable and the same deserves to be quashed and set aside and is accordingly quashed and set aside. यानी कि OTS के एज पर द नॉर्म्स आपको उसके कंडीशंस के हिसाब से बारवर को पैसा जमा करना है, and the demand for extension he cannot claim as a matter of right. Thank you friends. Namaskar.